Hello everyone, welcome to Coach Today by Livelaw, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an update from the Supreme Court, which has agreed to consider the writ petition filed by the state of Kerala challenging action of the President of India in withholding assent for 4 bills and the action of the Kerala governor in referring those bills to the President. A bench led by CJI Chandrachud issued notice to the Union of India through the Secretary of Ministry of Home Affairs and the Additional Chief Secretary of Kerala Governor Arif Mohammed Khan. Previously, let me tell you, the state had filed a writ petition in the Supreme Court challenging the governor's inaction. After the court issued a notice in November last year and criticized the governor for delaying the bills, the governor referred the 7 bills to the president. In February this year, the president withheld assent for 4 bills and approved the 3. The state of Kerala has challenged the action of the president in withholding the assent. The state has also challenged the governor's action of referring the bills to the president, arguing that none of the bills related to center-state relations required the presidential assent. The bills are related to amendments to laws concerning state universities and cooperative societies. Senior advocate and former Attorney General for India K.K. Venugopal, appearing for the state, submitted that there was a need for the court to lay down guidelines on when the governors can return or refer bills. The same bench today also issued notice to the Secretary to the Governor of West Bengal and the Union through the Ministry of Home Affairs in the state government's challenge against withholding assent on 8 bills relating to university laws in the state of West Bengal. In this petition, the state of West Bengal has contended that the governor's refusal to give assent to the bills without stating any reason was contrary to the mandate of Article 200 of the Constitution. While agreeing to issue notice on the petition, CJI asked Mr. Venugopal and Senior Advocate Jaideep Gupta, who is appearing in the petition filed by the state of West Bengal, to formulate the points. Advocate Venugopal replied that these points have been formulated in an application filed by the state of Kerala in the pending petition against the governor's inaction on the bills. The Supreme Court has today extended the interim order staying the directives of Uttar Pradesh and the state of Uttarakhand governments that the eateries along the Kanwar pilgrim route must display the names of the owners and the staff. The Kanwar Yatra is an annual pilgrimage by Shiva devotees to key Hindu sites to fetch holy water from the Ganga river. This year, the Yatra started on 22nd July. On 17 July, the Muzaffarnagar Senior Superintendent of Police required all eateries along the Kanwar route to display the owners' names, a directive that was extended statewide and is now being reportedly enforced across the states of Uttar Pradesh and Uttarakhand. 3 petitions have been filed in the Supreme Court against this directive by the NGO Association for Protection of Civil Rights, TMC MP Mahua Moitra and commentators Apurvanand Jha and Akar Patel. The petitioners argue that the directive threatens religious divides, violates fundamental rights under Articles 14, 15, 17 and 19 of the Constitution and compromises the privacy and safety of eatery owners and workers. Senior Advocate Mukul Rohtagi, representing the state of Uttar Pradesh, argued that the Central Law Food and Safety Standards Act of 2006 requires all food sellers, including dhabas, to display owners' names. He contended that the court's interim order staying this directive was not aligned with the central law, as petitioners had not mentioned it. The bench remarked that if such a law exists, the state should enforce it universally. Deputy Advocate General for the state of Uttarakhand, Jatinder Kumar Sethi, argued that the law mandates displaying owners' names and that the interim order causes issues, especially during festivals. He warned that unregistered vendors could cause problems, citing an example of vendors selling sedative-laced mangoes. The council appearing for Kanwar pilgrimage supported the directive, highlighting that misleading shop names such as Saraswati Dhaba or Ma Durga Dhaba suggest vegetarian food. but sometimes serve non-vegetarian dishes. This confuses pilgrims who follow strict vegetarian diets during the Kanwar Yatra. A bench comprising Justices Rishikesh Roy and S.V.N. Bhatti of the Supreme Court clarified that voluntary display of names is allowed, but maintained the stay against mandatory enforcement. Senior advocate Dr. Abhishek Manu Singhvi, representing TMC MP Mahua Moitra, told the court that Uttar Pradesh government had filed a counter affidavit late last night and requested time to file a rejoinder. The court then adjourned the matter to 5th August, stating that the stay order will continue till then. The Supreme Court has flagged deplorable conditions in Assam's detention centers where individuals with doubtful citizenship and deemed foreigners are kept in detention. The court highlighted a sorry state of affairs, saying that there is no adequate water supply, proper sanitation systems, or proper toilets. The bench of Justices Abhay S. Oak and Augustine George Massey made these observations after perusing a report from the Secretary of Assam Legal Services Authority regarding the detention center in Matail, Assam. Previously, the court had directed the union government to deport 17 declared foreigners detained in Assam transit camps, as no cases were pending against them. 4 of these foreigners had been detained for 2 years. The court had also asked Assam State Legal Services to inspect the detention center and report on the available facilities for the detainees. During the hearing, Senior Advocate Colin Gonzalez, representing the petitioner, argued that the deportation center housing 3,000 people was inadequately reviewed. He emphasized the need for a thorough inspection, that is to go to the area and meet people, similar to NHRC's approach. The court then asked the Secretary of Assam State Legal Services Authority to revisit the center to assess the quality and quantity of food served and the cleanliness of the kitchen in the area. The Secretary must submit a new report within 3 weeks, and the Union of India is to respond on the deportation issue within the same time frame. The Bombay High Court has come down heavily on the Maharashtra police after observing that a lady professor faced a departmental inquiry for referring to a book titled Shivaji Kaun Hota by Comrade Govind Pansare. This action followed a letter from the local police to her college regarding the book. The petitioner here was involved in a college lecture on August Kranti Day where Professor Dr. Vinayak Rao Jadhav spoke. Some students were upset by his comments about certain respected figures and began shouting and attacking him. To calm the situation, the petitioner professor referred to a book by Comrade Govind Pansare, which further angered the students and led to attacks on her as well. The next day, assistant police officer visited the college, demanded an apology from the petitioner for her comments, and when she refused, he wrote a letter to the principal urging action against her. Consequently, a departmental inquiry was initiated against the petitioner. A division bench of Justices Revati Moite Dere and Prithvi Raj Chavan pulled up the Maharashtra police for writing the letter to the educational institution to take action against her. The bench commented that the police in the instant case had exceeded its powers and thus the communication needed to be withdrawn. The judges further noted that the police justified its actions of writing a letter to the principal under Section 149 of CRPC, that is, proactive role of the police to prevent a crime. The judges said that there was no reason to invoke the provision as there was no occasion that the petitioner would have addressed any audience or resorted to some crime. The judges therefore asked the public prosecutor to either get the communication withdrawn or else it would pass strictures against the police. In response to a query raised by CPIM MP K. Radhakrishnan at the current monsoon session of the Parliament, the Union Ministry of Law and Justice has reported that there are currently 50 Constitution Bench matters pending in the Supreme Court. Of these, 35 cases are before a 5-judge bench, 8 cases are before a 7-judge bench, and 9 cases are before a 9-judge bench. This information is available on the National Judicial Data Grid. According to the list of pending cases, the oldest case dates back to 1994 and it concerns whether state governments are constitutionally empowered to collect sales tax based on annual turnover. The Union Law Ministry has also stated in its response that the Supreme Court has disposed of 2,192 Constitution bench matters since its inception. In response to concerns that the government's lack of interest might be causing delays in Constitution bench cases, the Law Ministry has clarified that the resolution of these cases is entirely the judiciary's domain. These cases often involve complex legal issues and require lengthy arguments and thorough analysis, making it impractical to set strict deadlines for their resolution. The Supreme Court has today approved the requirements in various states that persons seeking appointment as judicial officers should be conversant with the local language. A bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra dismissed a petition challenging the condition imposed by the Public Service Commissions of the states of Punjab, Karnataka, Maharashtra and Odisha. The bench observed that the requirement that a person seeking appointment as a judicial officer must be adept in the local language is valid. The bench pointed out that judicial officers once appointed have to deal with witnesses and evidence in the local language, and therefore such a requirement was totally justified. While rejecting the PIL, the court also said that in any case it was a matter falling within the policy domain. The Supreme Court today refused to entertain a petition challenging the eligibility requirement of 70% marks in LLB to appear for entry-level posts in the Madhya Pradesh Judicial Services. The court opined that such an eligibility rule ensures that better people join the judiciary. The petitioner here challenged the rule due to inconsistencies in making standards across institutions in the state. They argued that private colleges tended to be more lenient in grading students, often awarding higher marks, whereas state colleges followed a strict and more rigorous marking system. This disparity created unfair differences in students' grades depending on which type of institution they attended. Chief Justice of India D.Y. Chandrachud seemed unsupportive of the petitioner's argument, noting that other states like Maharashtra have similar judicial service rules. He emphasized that such rules are essential to ensure that the quality of judicial officers remains high and is not compromised. Further, the bench led by CJI dismissed the petition after noting that the challenge to the 70% marks eligibility rules was previously also rejected by the top court. In an important update, the Calcutta High Court has lifted a restraint imposed on West Bengal Chief Minister Mamata Banerjee from making any statements against Governor C.V. Anand Bose, who had sued her for defamation due to her claim that women had told her that they were afraid to visit the Raj Bhavan amid recent claims of sexual harassment against the governor. The CM had approached the Calcutta High Court in appeal after a single bench had restrained her from making any statements against the governor, which may be construed as defamatory in nature. A division bench of Justices I.P. Mukherjee and Biswarup Chaudhary, upon perusing the CM's appeal, has held that she had all the right to make statements against the governor as long as they were not defamatory in nature. It has thus modified the order of the single bench, which had earlier prevented her from making any statements against the governor. The appeal has now been listed for further hearing at a later date. Recently, the Ministry of Personal Public Grievances and Pension has negated the effect of 5-decade-old office memorandums by removing RSS from the list of banned organizations for central government employees. The bench of Justices Sushrut Arvind Dharmadhikari and Gajendra Singh of the Madhya Pradesh High Court, while dealing with a plea filed by a retired government servant seeking permission to join RSS, has remarked that the previous union governments had painted the whole universe of even the apolitical activities of RSS as communal and anti-secular, which had drastic consequences. The court lamented that it took the Union of India 5 decades to liberate an internationally famed organization like RSS involved in a plethora of apolitical activities from the don't join list of organizations for central government employees. The court also touched upon the diversity of activities undertaken by RSS and its affiliates that are not political. The court remarked that preconceived prejudice against a nationally and internationally acclaimed organization cannot govern the executive's discretion to classify an organization in the don't join list. The court added that RSS cannot be placed back on the list of banned organizations again without undertaking extensive research. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.